Okay, we're off to another topic for today that's going to take us a couple weeks because character evidence is another relatively major part of the syllabus. I think we take maybe 4 or 5 classes, and we do have a full day of review on character evidence. So it's not quite as massive a topic as hearsay was, but it's still quite important. And hopefully we'll get to the additional reading packet, which was called Queeg in your syllabus, but it's really Merrick, because it's really Merrick who is on trial for court-martial. Merrick is this gentleman right here. But of course, Captain Queeg is the main character in this Caine Mutiny film. And we'll hopefully get time to talk about it, because it makes a nice review of some of the character issues that we're going to do. So here's what we hope to cover today. Oh, that's not the right button. Here's what we hope to cover today. First, we're going to look at, oh, I forgot to tell you. Let's see where we are in the syllabus, because this is very exciting as we get closer and closer to the end. So you now know the first 6 questions that you ask. And that's, we're well over half, which is good because we're well over half done with the semester. And this is the 7th question. Does the evidence concern prior acts or some sort of propensity? Okay? And as you can see, since the 10th question is, does the prejudicial effect outweigh, and you've already learned about 403, we really just have 2 more questions to learn after this one. All right. I can feel the excitement. So we'll first talk about why character evidence is a problem. It turns out that character evidence is something that you in your everyday experience use all the time to make judgments about other people. So it seems unnatural at first when you find out going into court, the rules change, because, you know, we think of the court as a place where people's intuitions about truth-seeking apply. Character evidence is a totally counterintuitive approach to deciding whether or not a person committed a particular act at a particular time. Okay? We'll then talk about 404A, character to prove conduct. And we'll talk about the extent to which 404A says you can't do it. You can't prove character in order to prove that someone acted in conformity with that character. That's going to be a general rule that we'll repeat over and over again. But we'll talk about, initially, one exception to this, and this is when character is itself an issue in the case. And so we're going to have to understand, well, what is character? We're going to have to understand the usual condition in which character can't prove that you acted in a particular way. And then we'll have to understand the first exception, which is, but sometimes character is an essential element of an action. And we'll see an example will be something like defamation, where an essential element is whether the defamation was true, whether the person really is a bad person. Sometimes character is pertinent, and there are limiting ways in which you can prove character. And that's what will get us into 405, because what 405 does is 405 says, if character evidence is admissible, how can it be admitted? Can it be admitted merely through testimony as to a person's reputation to have a particular character? Can it be admitted as to a witness's opinion of a person's character? Or, and this is the most controversial, can it be admitted through proof of prior acts, which lead us to assume that the person has a particular character? So that's what 405 will do. And then, finally, we should get to United States v. Merrick, which, of course, is you think of as the Queeg case, because it's Captain Queeg, who's really on trial. All right. Let's say that someone says to you, oh, did you hear about Doug? Doug got into a fight the other night. He was at a party, and he came out, and he was, you know, he's pretty beaten up. And the question was, did Doug start the fight? Now, what are the kinds of questions you would ask in order to decide if Doug started the fight. Of course, you might want to know the specifics of what happened on that particular night. But assuming you don't know anything about the specifics, what sort of things would go through your head in trying to decide whether Doug, in fact, started the fight, or whether Doug was just there to enjoy himself and some random, some hyper steroid-driven, frat brother just threw himself onto Doug in a fit of male dominance? Okay? Well, wouldn't you ask things like this? Wouldn't you say, well, I don't think Doug is that kind of person, right? I don't think Doug is the kind of person who would start a fight. And if someone said, well, what do you mean by that? And you'd say, well, I've known Doug for a long time, and I've seen him at other parties, and he actually gets more passive the more he drinks. He doesn't get more aggressive like many of us do. And these are perfectly natural things for you to talk about and think about when you're trying to decide whether Doug started the fight on a particular evening. So if you put this a little more schematically, if I say to you, well, did Doug start the fight, right? Did Doug do something that he's been accused of doing? You would instantly and automatically ask these kinds of questions. You'd say, well, is Doug the kind of person who starts fights? Right? And in order to decide if Doug is the kind of person who starts fights, you would rely on this. Has Doug ever started a fight before? Right? He's not that kind of person is another way of saying, I've never seen him do that. I don't think he's ever done that. Perfectly natural. Okay? Now, in the law, there are specific terms for these kinds of arguments. Okay? Did D do X is easily translatable into did the defendant do some crime, or did the defendant commit some tort. But this is translatable as character to prove conduct, right? If the defendant is the kind of person who starts fights, then you're more likely to conclude that he started the fight. That's called character to prove conduct. So character is the kind of person you are. Now, character can be general or specific. So you can be a generally good person. That's general character. It can be specific. You can be a good person but have a tendency to punch people when you're inebriated, right? That would be a specific character trait. And that person might be a very nice person if he's sober. That's all character. What about this? Has the defendant done things like X before? Well, think about your reasoning when you ask this question. Okay? Your reasoning goes like this. If the answer is yes, how can you then conclude that this answer is yes? Sure, he's fought before. That doesn't mean he fought this time. And your reasoning would be, if he's done this kind of thing before, if he's done it a lot, then I would assume he's the kind of person who gets into fights. And then I would assume that he got into a fight on this particular occasion, that he started the fight. So notice that this works through this in order to get to the conclusion, right? So for that reason, the law calls this other acts to prove character, to prove conduct. Other acts to prove character, to prove conduct. And you want to be sure that you understand that the other acts don't directly prove that the defendant started the fight on this particular evening. There's no necessary reason why it should. The only way it can is if you make an inference about what those other acts mean, and that inference is that those other acts make Doug the kind of person who starts fights. And that's why it's other acts to prove character, to prove conduct. Well, guess what? You use this kind of reasoning in your everyday logic, right? You would ask these questions immediately if anyone told you that Doug might have started a fight. The law says no. The law, at least, has a strong presumption against not allowing you to prove character, not allowing other acts to prove character, to prove conduct. And you'd say, well, what's left? Well, did you see the fight? Were you at the party? There might be witnesses directly to the event, and that's what the law says we should rely on. Okay? Well, how can the law not want this? This is clearly probative, right? This is clearly relevant. Certainly you think it's relevant as long as you agree with me that your intuition would teach you to ask these questions in order to try to decide whether Doug started the fight or not, right? So they're clearly relevant. And you know that the law only disallows relevant evidence if something outweighs that relevance, and that something, of course, is, tip of your tongue, prejudice. The law says, no, we don't allow character to prove conduct. We don't allow other acts to prove character to prove conduct, and we don't because the evidence is prejudicial. Now, remember what prejudicial means. Prejudicial means that the jury may overweigh the evidence, or the jury may use the evidence for an impermissible purpose. Remember those two bases for prejudice? Well, it's the latter that really controls here. What the law thinks is that juries may convict or may find for a plaintiff when they hear this kind of evidence, not because they properly use it for determining whether the defendant started the fight on a particular evening, but because they conclude that the defendant should lose simply because he has a bad character. All right? So the logic is that the jury will convict simply because the person is bad. Now, you can see why that might not operate if you're talking to somebody about whether Doug started the fight or not. You want to decide if Doug started the fight. But if you're in a courtroom and you're asked to award money to the person who says they were beaten up by Doug, you might decide to give them money not because you really think that Doug started this particular fight, but as you hear about Doug's awful character, and as you hear about other people that Doug has beaten up, apparently with impunity, right? You don't know, but you guess that he hasn't been punished for those other crimes. You might decide to vote for the plaintiff or vote against Doug simply because you think he's bad. And so although your everyday reasoning teaches you that character evidence and other acts to prove character are relevant, the law recognizes that they are highly prejudicial and therefore inadmissible. Okay? So I think that logic is pretty simple. Let's look at Rule 6404 and see how it's spelled out. Okay. Oh, and I was really happy. I did hear back from one Apple consumer, maybe you, that you had trouble with the slides. Now all of a sudden I realize I can easily scan and see the apples. I never noticed that before. So the apples were having trouble downloading the slides? Yes? And I think I fixed it. It's because you don't have Book Antiqua font. I'm sorry. And so I switched to Times New Roman, and I think it's working now. Yeah? Good. All right, good. I used to just say, get a PC. But then I got a letter, cease and desist letter from Apple, and can't say that anymore. Character evidence generally. Evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. And here's what you want to write, which should look just like those boxes. You can't prove character in order to prove someone acted in conformity with their character. Right? You can't prove character in order to prove that someone acted in conformity with their character. You can't prove that Doug is a belligerent person in order to prove that he was belligerent on a particular night. Can't do it. 404A. Can't do it. This will be easy to remember. All right. Immediately, though, there are exceptions. There are exceptions. This seems fair, but what if the defendant wants to introduce character evidence? Right? What if Doug says, hey, man, not only did I not start the fight, but I was just defending myself. And how is Doug going to prove that he was just defending himself? Don't you think that maybe the defendant has special rights to introduce evidence that we might not otherwise admit against the defendant? Okay? And hopefully your intuition is, yes, I think that criminal defendants should have a special right to introduce character evidence. And it turns out that that's what the first exception says. So 404A1 refers to the character of the accused. Evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same, or if evidence of a trait of character of the alleged victim of the crime is offered by an accused, evidence of the same trait of character of the accused offered by the prosecution. Now, the language gets kind of convoluted because you'll notice now it's referring ahead to 404A2, and we haven't talked about that yet. So let me give you the simple rule in a second. That's the first exception. So far, just to keep in your head, not to write anything down, you want to realize that the accused can offer evidence of his good character, and the accused and the prosecution may be able to prove that the accused is a bad person because the accused has attacked the victim's character. Okay, now keep that in your head. Don't write it down yet because this is all in my slides, so you'll see this. Except two, another exception, is that the accused may offer a pertinent trait of character of the victim of the crime or by the prosecution to rebut the same. Now, simply put, what this language is all going to say is this. In criminal cases, because notice it refers to the accused, in criminal cases, the defendant can offer her pertinent character traits, and the prosecution can rebut the same. Okay? The defendant can offer her pertinent character traits, and the prosecution can rebut the same. So notice that the prosecution can't start the process of character evidence. The prosecution can't initiate an attack on the defendant's character. But the prosecutor can respond to the defendant's initiation with rebuttal. And for that reason, when the defendant puts his or her character in issue, is the way they'll put it, although it's a loose way of speaking. When the defendant offers evidence of his or her good character, this opens the door. And you'll hear that expression a lot. You open the door, counsel. You open the door. It opens the door to the prosecutor now rebutting that. Okay? Tit for tat. And, remember there's language about the victim. The defendant can offer the pertinent character traits of a victim, and the prosecutor can rebut with traits of the victim. And this thing is new. This little language is new. Try to keep the excitement level up. Or the defendant. Okay? All right, look at that for a minute and think about it. So, character inadmissible. Defendant steps forward and says, but I have a good character. Prosecutor then responds, okay, now I can say you have a bad character. Right? You open the door. Defendant steps up and says, victim has bad character. And of course, that would be typical in a some kind of self-defense case. Okay? All right? And the prosecutor can then say, oh, you're attacking the victim now. Well, now it's fair game. Now I'm going to show the victim has a good character. Or, and this is the new language, is the prosecutor can respond to attacks on the victim's character by attacking the defendant's character. Right? And you see why that makes sense? So Doug says, hey, let's say the plaintiff's name is Paul, just for P&D purposes. So Doug says, hey, Paul started the fight. Paul is a violent person. Prosecutor can then say, okay, now we can prove that Doug's a bad person in response to proving that Paul is a bad person. Or the prosecutor can say, no, Paul is really a peaceful person. Okay? Does that make sense? All right. And there's specific language. There's specific language with respect to self-defense in a murder case. And this is going to test your knowledge of the difference between specific acts and general character evidence. The language says this, and then I'll tell you what to write. Or, this is another exception that is okay, or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. And I'll tell you what to write and then ask you a question about this. This may sound redundant to you. And if this sounds redundant, then you're not getting it. Okay. And in a murder case, the prosecutor can prove the victim was peaceful to rebut self-defense. All right. I'll let the clickies die down. And ask you, wait a minute. Didn't we already say this? Didn't we already say that the prosecutor can prove that the victim is peaceful? As long as the defendant raises the victim's character? Why do we need this? Uh-huh. He has to... So wait, doesn't the defendant always raise self-defense by attacking the character of the victim? Why not? How could the defendant raise self-defense without attacking the victim's character? Yeah, very good. So the answer to this is the defendant might attack the victim's character in order to make a self-defense claim, but the defendant need not attack the victim's character. Remember, you've got did D do X, character, other acts to prove character. The defendant could go after the did D do X by having eyewitnesses to the fight itself testify that the victim was the aggressor. That would not be opening the door to character evidence under the exceptions we've seen before this one. That would not open the door. But in a murder case, and notice that a murder case, the victim cannot speak for herself or himself. In a murder case, any self-defense argument that the defendant makes, any self-defense argument, whether it be based on the character of the victim or based on eyewitnesses to the actual event, opens the door to the prosecution to rebut that self-defense claim by proving that the victim was peaceful, by offering character evidence that the victim was peaceful. Okay? Yeah. No, that would not be opening the door. If you said, yeah, he's a bad person, you have to offer something that reduces the likelihood that you're guilty. I mean, it's pretty safe that, you know, that's all you'll be doing. So, anything else? Well, let me summarize. So you can't do this, right? Except criminal defendant regarding her character. So criminal defendant can say, I'm not a bad person. I'm not the kind of person who would have committed this crime. Except criminal defendant regarding the victim's character. A criminal defendant can always attack the victim and say the victim is the kind of person who would have started it, assuming, of course, that the victim's character is relevant in some way. You know, there could be a murder case, and you could say, well, I want to offer evidence that the victim was a drug dealer, was a bad person. No, that's not even relevant. Okay, so you've got to pass the relevancy test. It would be relevant to a jury. A jury would say, good, kill the mother of your child. Sorry. That was a quick rescue attempt. Prosecutor to rebut defendant's character evidence or to rebut homicide self-defense. Okay? And notice that this rebuttal can take different forms. This rebuttal can take the form of attacking the defendant's character or rehabilitating the victim's character. Okay. All right. Now, if you have those strange and wacky rules in your head, then you're ready for some simple hypos. So let's do it. Let's do some simple hypos. Defendant is charged with assault and battery of victim. Plead self-defense. Good. Everything's pretty clear. And here's A, B, and C. A, B, and C are three potential witnesses. A thinks the defendant is a violent person. B thinks the defendant is a peaceful person. And C doesn't have any opinion about the defendant, but thinks that the victim is a violent person. Okay? So A thinks the defendant is bad. B thinks the defendant is good. And C thinks the victim is bad. All right? Let me ask you this first question. Prosecutor in case in chief. Oops. Oh, I should have had the build on this. Kind of takes the excitement away. Can the prosecutor call A in its case in chief to testify that the defendant is a violent person? No. Very good. Character to prove conduct violates 404A. Now, if you can say more than just read that, if you can put that into a form of a sentence, such as proving character in order to prove conduct on a particular occasion violates 404A, then I'd be much happier. But that's the easy answer. Prosecutor can't initiate. Okay, prosecutor can't initiate. All right. So prosecutor doesn't call A. We're not assuming any character evidence has been introduced. The defendant calls B, who will testify that the defendant is a peaceful person. Is this admissible? Yes. Defendant can introduce evidence of his own pertinent character traits under 404A1. Now, pertinent is something that we have not defined, but hopefully you already have a good sense of what pertinent is, right? Pertinent means relevant. And now the defendant has, quote unquote, opened the door. Now A, who hopefully hasn't left the country, can be called in rebuttal to testify that the defendant is a violent person. Okay? So the defendant can open the door. Well, assume that the defendant says, no, I'm not going to call B because I know about all those A's out there, right? I don't think I can plausibly argue that I'm a peaceful person. So I'm going to call C, who will testify that the victim was a violent person. And this actually is probably a more likely scenario, at least given the typical crime in which the defendant has a criminal history, right? And usually the defendant with a criminal history hangs out with other people with criminal histories, so your better bet is likely to go after the victim. Well, unfortunately, if this happens, and this can happen, the defendant can introduce evidence of his victim's pertinent character traits under 404A2, the prosecutor, under a relatively new rule, can now call A. So the defendant can't avoid an attack on his character by going after the victim's character, right? That new rule, that exciting new rule, makes that a bad strategy, okay? And remember these additional things. If the defendant only presents evidence that the victim attacked first, but doesn't offer it as a character argument, but says, on that night, he attacked me, the prosecutor can rebut with character evidence only in a homicide case, right? Murder case. Now, you're probably saying, well, criminal is interesting, but I'm not going to be a criminal lawyer, so I don't need to know any of these exceptions. I know that 404A, and hopefully you recognize this, 404A doesn't limit itself to criminal cases. The exceptions sound like they do. So 404A says in civil cases, you can't prove character, period. And the answer to that is, well, yes, that's the language of the rule, but what the courts will do is consider if the conduct in a civil case is inherently criminal, like a civil rape case. You'd say, well, surely that's criminal. That would lead to these exceptions, right? Or imagine, remember in the O.J. case, after he won the criminal case, he was then charged in civil court for homicide. And you might wonder, why don't you see more civil cases of homicide, right? It's a great civil claim, right? It's a serious, serious tort. Well, the reason is because usually murderers don't have very much money. That's the only reason. But anyway, so the civil case, Could OJ rely on the 404A provisions in defending himself against a civil claim of homicide? And the answer is yes, the courts will allow it, even though it's not in the language of the rule. Okay? Okay, let's talk about what pertinent means. What is pertinent? And what I want you to do is imagine that the defendant is charged with possession of heroin with intent to sell. And of course, intent to sell usually just means you have a lot of it. That's why you can make good money as an expert witness if you know how much someone can reasonably use. Because you'll be called to testify that, no, I don't think 2 kilos is a usual dose. Okay? I actually have no idea. 2 kilos, what is that? Truthfulness. Could the defendant say, hey, I'm a truthful guy? It turns out that lots of drug dealers are truthful. You know, the honest drug dealer, right? He says it hasn't been cut with rat poison. I'm giving you exactly, 4 grams. You can trust me. Those guys are all over the place. It does not rebut a charge of possession of heroin with intent to sell by offering character for truthfulness. What if you want to have your mom testify? And it is amusing to watch some of these cases where the only person you can bring into court is your mom. And even your mom says, yeah, we thought he might be a bad one. Objection. Mom, well, you never cleaned your room. I can imagine my mom just going off on me if she testified in my defense, so I would just never call her as a character witness. But anyway, assuming that someone is just going to testify that you're generally a good person, that is not considered pertinent, but this is always pertinent. If you can get them to say that generally, if I can get it to come up, you'll see what it is, law-abiding, that's different. That is always okay. But most of the time, sort of generic, the kind of stuff that you write, well, I hate to say this, but that you write in a recommendation when you really don't have much to say, those things would not be pertinent traits of character, except for this one, because notice that it specifically says you would not violate the law. Okay? So that's what pertinent means. You can always argue about that. Now, there's one more exception under 404, which I'll show you, but you won't want to write. But it will prepare you for more later. This language, except 3, character of a witness, evidence of the character of a witness is provided in Rules 607, 608, and 609. Uh-oh. We've got more rules coming. And you don't have to write anything right now. But just remember this. This is the reason why when I teach character, I also teach credibility. Credibility refers to these rules. Because it turns out, just to give you a sneak preview, it turns out that the rules with respect to attacking the character of a witness for their truthfulness is wide open. And there are always, and as you'll see, some of the most interesting hypotheticals and real-life situations, once you're a real lawyer, are situations in which you might be able to attack someone through either character or credibility attack. So you might be able to make use of 404A1 or A2 or A3, and you'll have to choose which works best. So that's something we'll see in a week or two. Though it can't be too long because we don't have that many weeks left, do we? Okay, so now hopefully you have a pretty good handle on the somewhat weird rules. And the reason why they're somewhat weird is generally the law says, no, don't do it, but we want to be deferential to defendants who have a right to present evidence. That's basically what we've seen thus far. So let's say you're able to prove character. How can you do it? How can you do it? And here's what 405 tells you. And this is going to seem even, if 404 seemed a little convoluted, 405 will seem more convoluted. So get ready. 404A says reputation or opinion. In all cases in which evidence of character or a trait of character is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. Okay, and what you want to write is, oh no, wait, you don't want to write anything yet, sorry. On cross-examination, inquiry is allowable into relevant specific instances of conduct. here you go. Here's the slide which you want to write. If character evidence is admissible, can prove by reputation or opinion. If character evidence is admissible, can prove by reputation or opinion. Okay. And in cross X, you can ask a character witness about specific instances of conduct. Specific instances of conduct. So there's a distinction between reputation and opinion on the one hand, for which there's a broad rule of admissibility, and specific instances where you're limited to asking a character witness about those specific instances. Now, we haven't talked about specific instances, and this is going to add a new complication to the character evidence rules. There's this clear distinction in several places in the rules between reputation, opinion evidence on the one hand and specific instances on the other. And hopefully you remember that we had talked about that middle box was character to prove conduct. Specific instances was this box down here, which we haven't talked about yet. But now we see a reference to specific instances, and let's see what that means. Yeah. Yes. Okay, the question was, actually it just occurred to me, maybe you didn't hear the question, right? Never thought about that. Did you hear the question way in the back? At least you can hear me now, right? That's a good. Well, the question was, would it include the defendant taking the stand and testifying about his own good character? And the answer was yes. Okay, so let's think about this. Because B now refers specifically to specific instances of conduct. Okay? B says, in cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of that person's conduct. So 405B also refers to specific instances. Okay? And so what you want to write is this. If character is an essential element of a claim or defense, you can prove by reputation, opinion. We already know that, but I want to remind you, you already know that. But you can also prove specific instances. All right. So to make sure you understand what I've just told you, answer this question. So if character is admissible but not essential, right? If it falls under the rules of 405A but not 405B, what form of proof is not allowed? Specific instances of conduct. So the law is telling you, and we're going to spend a lot more time on this tomorrow because we haven't looked at 404B, and the reason we haven't looked at it is it opens up a whole nother can of worms. But what the law is telling you thus far is specific instances of conduct are, generally speaking, less allowable than reputation or opinion evidence. And reputation or opinion evidence means, I think he's a peaceful person. That's opinion. Or everybody thought he's a peaceful person. That's reputation. Okay? All right. Now, just to give you a peek at 404B, let me show it to you. So this will complete this picture of why specific instances are disfavored generally. Here's what 404B says. Now, this is just a peek at it. Tomorrow we're going to go into detail on what this means. But here's what you want to write for now. Other acts to prove character, to prove conduct, are inadmissible. Other acts to prove character, to prove conduct, are inadmissible. Okay. So what you definitely want to have in your head now is those specific instances of conduct are harder to get into evidence than reputation or opinion. And the reason why you want to get that into your head is that seems counterintuitive, right? That seems counterintuitive. Why does that seem counterintuitive? Well, let me ask you this way. Why would you be less allowed? Why would you be more restricted from proving prior bad acts than you would in some generic statement about, well, I think he's a peaceful person, or the word on the street is, the word on the street, that's good evidence? Specific acts is bad evidence? Well, I hear Doug's a real hothead, right? Versus Doug has beaten up X, Y, Z. That doesn't make any sense. It doesn't make any sense because the most convincing evidence that Doug is a hothead is whether he's beaten up lots of people before, right? That's certainly better evidence than just some reputation or just some guy saying, I think Doug's a, I think he's a hazardous person. Well, how can the law possibly make this distinction in favor of reputation and opinion evidence? And the reason has to do with the rationale for not allowing character evidence in the first place, which is we're worried about prejudice. It's not the limited probative value that we're arguing about, it's the prejudice. And what would be more prejudicial and what would take more time? Allowing someone to take the stand and say, I think Doug's a bad guy, versus witness A testifies that Doug hurt witness, victim X. Witness B proves that Doug beat up witness Y. It would clearly be more time-consuming and prejudicial to offer other acts. So although it may seem counterintuitive to you that the law treats reputation and opinion evidence favorably and specific acts disfavorably, the reason is consistent with the rationale for the character evidence ban. Okay? That's how strongly the law worries about the prejudicial effects of character evidence, either in the form of reputation or opinion, where it has some limits, or in the form of prior acts, specific instances of conduct, where it has more severe limits. Okay. You're maybe saying now, if you've been following me closely, you're maybe saying, but wait, you can offer specific instances of conduct. You can offer it. And you'd point to 405B, which says if character is an essential element of a claim or defense, then you can offer prior acts. Well, that may be a huge loophole. Yes? No. Character is not very often an essential element of claim or defense. And this is one of the most common errors that students make, is they think that if you're charged with a crime, then an essential element of the crime is that you are a criminal. That sounds plausible, right? Of course you're a criminal. Well, you don't have to be a criminal to commit a crime. You can be a generally peace, law-abiding person, but you can commit a crime on a single night, and you're still guilty, and the fact that you've been law-abiding all your life, right, is not the charge. It's not an essential element of the charge, and it's not an essential element of your defense. You can easily say in your defense that you are a criminal, but you didn't commit the crime, right? So it's neither necessary nor sufficient that you be a criminal, a character of a criminal, in order for you to have committed a crime. So in a theft case, the fact that the defendant is a thief, as a character of a thief, is not an essential element. And in fact, it's very hard to find a crime for which the defendant's character is on trial. In fact, I can assert this. It is impossible. There are no character crimes. There are no crimes for which your character is an essential element. Now, it may be an essential element of a defense if you argue that you are or were insane. Okay, so it might be part of your defense, but it's never part of the crime itself. What about negligent entrustment? This is a tort. This may not even be a tort you're familiar with, but this is a good tort to know when you start lending out your car to drunk people or to your little sister. The character of the person entrusted to is an essential element. So the plaintiff has to prove that when you entrusted the car to this particular person, that person had a bad character. Bless you. What about a defamation suit in which the defendant has said that the plaintiff is an adulterer? It turns out that the courts will allow evidence of specific acts to prove or disprove this claim, right? So you can say that plaintiff's character as an adulterer is in issue. But of course, you have to look closely at a defamation case, because a defamation case could sometimes assert something very specific, right? That you made some specific claim, and it wouldn't necessarily open up an examination of the character of the plaintiff. What about child custody cases? It turns out that child custody cases, and this is why it's so either fun or terrible being a family law litigator. You know, it opens every door. And of course, when you're divorcing someone, all of a sudden, all their faults become so clear, right? So intensely clear. Every damn day, right? And have you seen, there's this, I can't remember what reality program it was, but it was hilarious. It was couples where they'd come in and they'd complain about their spouse or their boyfriend or girlfriend, and then they would install a secret camera. And then the audience would vote on which spouse was in the right. And so my favorite was the woman says, he always makes noise when we're watching TV. You know, he noisily eats, he sniffs, he does all these things. And my wife's watching the show with me, and she's going, yeah, he does. And I'm thinking, oh, damn. And then they get the hidden camera in there, and the guy comes in and sits down next to his wife, and they're watching TV, and he's going, and she's like, shh. And my wife's over there looking at him going, oh, listen to him. And afterwards, the audience is like, no, he's not noisy at all. He's not noisy at all. And my wife's like, what do they know? Anyway, where am I? Oh. So this is a major disincentive to divorce, is you have to hear about this, you know, through week after week after week. It's hard enough hearing it at home, but in an open courtroom. So the parent's character, as at least as fit parents, if there's a child custody issue, character is in issue. And remember, what does that mean? If it's an essential element, then everything is admissible. Specific acts, reputation, and opinion. Okay, so 405, to summarize, says this: reputation is admissible anytime character evidence is admissible. Opinion is admissible anytime character evidence is admissible. And other acts, limits. If character is an essential element of a claim or defense, then other acts are admissible. And this is something we haven't talked about, but I did give you this rule, and it is in your notes. Cross-examination regarding character. Okay, and we haven't really explained that. Cross-examination regarding character. Now, it's true that while we were watching this reality program, I'd gotten out a big box of crackers. And so maybe she was mixing me up with the guy on TV. So what is cross-examination regarding character? Right? What is cross-examination regarding character? Well, the way cross-examination regarding character works is that if there is a character witness, the person who cross-examines that character witness can test their opinion or reputation. And they can test their opinion or reputation by asking them questions about the foundation for that opinion or reputation. So it would go like this. Defendant offers a witness to say that defendant is a law-abiding person. Okay? And he testifies in the form of an opinion. The prosecutor could then say, in cross-examination, well, did you know that he committed this crime and this other crime and this other crime? And notice that the prosecutor is asking about specific acts. But the prosecutor is not introducing those prior acts into evidence to prove that the defendant had a bad character. The prosecutor would say that he's asking about those bad acts to assess the foundation for the character evidence that has been offered. Get that distinction? Now, if that sounds to you like a fishy distinction that the jury will overlook, then you're in good shape. You understand. And if that sounds to you like something we talked about with respect to expert witnesses and inadmissible evidence, then you're really on top of this, because it is analogous to that, right? Remember that the way that you could sneak in inadmissible evidence is you could get the expert to testify, in my opinion, X. And then you'd say, and what is the basis for your opinion? And the expert would say, all of these pieces of inadmissible evidence. Objection, inadmissible. And you'd say, I'm not offering this to prove the truth of these A, B, and C's, of these facts. I'm offering these facts to provide the foundation for the expert's opinion, right? Here, analogously, the prosecutor would say, I'm not asking about the bad acts that the defendant did to prove prior acts, to prove character, to prove action in conformity therewith. I'm offering these bad acts to undermine the opinion of this character witness. Now, we're going to come back to that, because the law realizes how sneaky this is. And you'll see that the law places limits on how far this cross-examination can go. And what do you do if the guy says, no, I've never heard that, and I don't believe it? What do? You'll see that you're very limited. But that's the distinction, is it's not proof of those acts. It's use of those acts to question the foundation of the character witness. Okay? All right. So let me ask you this. I don't have a build on this, but just let you think about this. Hopefully, although this is an easy thing to miss, hopefully you would have said, well, wait a minute, reputation is hearsay, right? Reputation is hearsay. And it's out-of-court statements offered to prove the truth of the matter asserted. So witness says, or witness testifies, I should say. Witness testifies, D has a bad reputation as a cruel dude. They say he was ruthless. They say he was rude. Life in the fast lane. Surely makes you lose your mind. Life in the fast lane. So the witness testifies that the defendant has a bad reputation. Anybody want to call that one? Eagles. No? No recognition? Too old school for you guys? Listening to Making It Rain? I know what you're talking about. All right. So witness testifies the defendant has a bad reputation. But notice what witness is saying. A bad reputation is what other people are saying about the defendant. So he's quoting out-of-court declarants, right? It is hearsay. But I forgot to teach you 803.21. I'm really sorry about this. There's an exception for reputation evidence. Okay? That's something you can stump your UCLA friends with. I'm sure they don't learn about that in their evidence class. All right, so let's run through some more opinion and reputation questions in the guise of that hypothetical that we did a moment ago. And then we'll hopefully we'll then be able to take our break. Assuming that the witness A is allowed to testify that the defendant is aggressive. And so to think back to our example, remember, when would this happen? Would this happen in the prosecution's case in chief? No. Would this happen if the defendant attacked a victim? Yes. Would this happen if the defendant said, I'm a good guy? And it could be the defendant taking the stand and saying, I'm a good guy. Or it could be the defendant offering an opinion of someone else who says he's a good guy. Yes, yes, yes. Those are the ways in which this could happen. And assuming A wants to say this, the defendant had a short fuse. The answer is yes. That would be considered opinion. You don't have to say, in my opinion, the defendant was a violent person. You can just say it. As long as you say it in general terms, it's not considered specific acts. Everybody thought the defendant was a maniac. Yeah, that's a good example of reputation, what everybody thought or what everybody said. And you couldn't say this, though. You couldn't say the defendant was in lots of fights because those are other acts. Now, of course, you're looking at this and you're saying, well, there's a pretty fine distinction between this and the defendant had a short fuse. And yes, indeed, there is. But notice that what the rule is keeping out is specifics, which will then take up more time, become more and more convincing that maybe we ought to find this guy guilty just because he's a hazard, not because he committed this particular crime. Okay? All right. Let's look at that distinction between proof of specific acts to prove character to prove conduct and reference to specific acts to undermine the opinion of a character witness. So assuming that B is allowed to testify that the defendant is peaceful, okay? Assuming that B is allowed to testify the defendant is peaceful, could the prosecutor present rebuttal evidence of specific violent acts? Well, you know that the prosecutor can rebut, but the rebuttal has to take the same form as the initial character evidence. So since the witness B is only allowed to testify as to opinion or reputation, the prosecutor can only introduce rebuttal evidence of opinion or reputation. Okay? Because 404B says you can't introduce prior acts to prove conduct. You can't offer prior acts to prove character to prove conduct. You have to rebut in the same form in which the original character evidence is introduced. But what the prosecutor can do is ask B about those specific prior acts in cross-examination. And the theory is that the prosecutor is not asking about those acts to prove character, but is asking about them to test B's knowledge. Okay. Yeah. Yeah. Although usually the prosecutor has really good grounds for believing them, and usually the redirect would rather just drop them. But yes, they can. They can. Yeah. No. No. Yeah. Yeah. So the way to think about it is that specific acts are only the entitlement of the cross-examiner. And even then, only when questioning someone who's a character witness. Now, there are two ways in which this distinction is very important, okay? And I have one on the slide and one I don't know why I didn't put it on the slide. I guess I'll talk about it a lot in the next few days. So there are two ways that you can say these are really different. These are really different between offering rebuttal evidence that the acts occurred and asking about it on cross-acts. One way to think about it is that when you can ask about it on cross-acts, but you can't offer independent evidence, there's a nice term to remember. It's called a bar on extrinsic proof. A bar or a ban or a limitation on extrinsic proof. Extrinsic proof means when you have to do something affirmatively in the form of a witness or some other evidence in order to prove that something's true, right? So what's not extrinsic? Not extrinsic is when you can extract the information from your opposition's witness. And notice that that's what you do when you cross-examine a character witness about some prior bad act, right? You can ask them, but you can't then go on and prove it. You can't go on then and prove it. Oh, now I remember why I don't teach you the other distinction. The other distinction is something called take the answer, which you really have to get into impeachment and the rules of impeachment to understand. But to make you happy now, I'll tell you this. One of the real limitations is that if you cross-examine someone on this prior act, and they say, no, I don't think that happened, you can't then prove it through extrinsic evidence. You have to what's called take the answer. So a real bar in extrinsic proof says if you can get him to admit it, okay. But if he won't admit it, you can't offer it. The inquiry stops there. Okay? Okay, good. Let's take our break, and when we come back, we'll be able to do the Cain mutiny case. Come back at about 10 till.